So you are suggesting not only, I think this is indisputable, that the original fill in the blank, meaning, intent, understanding, would not support the federal constitutional sex discrimination cases of the 70s that, as a matter of constitutional law rather than legislative grace, dismantled coverture and gave women a full right to the public sphere, but also that's original meaning. You think the meaning of the Constitution won't allow that? I mean, there are many other forms of meaning for any text than originalism, however capacious,
I would say that you can understand what the Constitution is in many different ways. And so on some understandings of the Constitution, which would include case law and other things, those constitutions would constitutionalize the very things that you're talking about. Much of the debate is about what the Constitution is, it seems to me, more than about how to understand it.
Right, but the text can easily be interpreted to achieve the results I want.
I think text can be understood in any way you wish it to be understood if you espouse a particular author.
I'm not reading out.
I completely agree with what you're saying. I found it striking.
Not any text, this text. This text I'm lucky about.
I actually think any text can be construed anyway if you posit the right author. But your example of the French Constitution was striking to me because you said
I didn't give an example of the French Constitution.
Well, the French Code, I'm sorry. Yeah. You said that it's understood that they did not want the French Code to be interpreted according to its original intent, which it seems to me itself is an originalist claim. So if it's astrology, I don't know how it can be said that that's the right understanding of the code.
I am not saying that that is the correct interpretation of the French Civil Code. I am saying I find it interesting as a scholar that that's the way they said at the time it should be interpreted. I'm intrigued as to what it is about them and their history and their system, maybe the fact that they're Catholics, maybe not, that leads them to say that so explicitly. I mean, that's the context in which I wanted to introduce the astrology analogy. Not to say that, originalism is foolishness the way astrology might be foolishness, but that there are a variety of different ways of doing it, as Professor Fallon pointed out, but there are also a variety of different levels of seriousness and intensity with which it can be done. And even then, it may not be outcome determinative. And even then, you may not like the outcomes it determines.
Any other panelists on Heller? Professor Whittington?
Sure. I mean, I think that's all got to be true, right? I mean, so it's hard. I think it's hard to look at Supreme Court opinions and think that these are ever going to be the exemplars of the highest quality pieces of argument of any sort that you would expect to see, whether they're doctrinal arguments or historical arguments or structuralist arguments or any other form of constitutional argumentation you'd be looking for. They're always problematic. And sometimes they're better than other times, but they're problematic pieces of work. And so it seems an odd complaint to point to Supreme Court opinions and say, the Supreme Court doesn't do its work as well as one would imagine, and therefore originalism is somehow flawed. Although, I have to admit, I find originalism interesting primarily as a piece of political theory, and think of it primarily in those terms, rather than think of it primarily in terms of a legal practice and what the Supreme Court does with it. I'm constantly disappointed by what the court does just in general, let alone what the court does when it tries to do originalist work, but it's certainly the case that the court has its problems. What I find reassuring about Heller, or attractive about Heller, as well as some of the court's other cases, is its making efforts. Is that it's engaging in historical arguments, that it's taking historical arguments seriously, which will encourage more historical arguments be made to the court. Hopefully it will encourage the court itself to engage more deeply in these kinds of things. I don't hold out great hopes that that's true, but what one can always imagine that you'll see more of those things. And the wider the array of justices who do that, the better off you're going to be. What originalists have said in the past that they hope for, and what I think you would hope for, is that you would see a wide range of justices, whether it's in these cases or the sovereign immunity cases, for example, as you mentioned Souter earlier, who take historical arguments seriously, offer different kinds of historical arguments, and try to engage each other about who's getting the history right, how do you interpret that history, what kinds of historical arguments ought you to use, what kind of evidence is the best evidence to use, and how should we interpret that. And those arguments are not always going to be easy to sort out. There's nothing easy about engaging in these kinds of originalist arguments and materials, and there's no reason to think that at the end of the day, once you're engaged in originalist arguments, you're all going to come to the same conclusion. Sometimes there's still going to be disagreements about what the right answer is.
Could I be really quick on this? Several things about Heller. First, all of the justices of the Supreme Court engaged totally on originalist grounds, and all of the justices of the Supreme Court came out exactly where you would expect they would have come out if they were able to vote in a totally unconstrained way about whether it ought to be permissible for the District of Columbia to ban guns. Second, the justices of the Supreme Court in Heller were doing originalism in different ways, the point that I was making about less than fully specified theories. As I understand it, Justice Scalia for the court purports to be doing something like the original public meaning, whereas Justice Stevens for the dissent purports to be doing something like an originalism of original intent. And if everybody worked at this really hard, then maybe someday everybody would come to a fully specified theory in which everybody would agree exactly what kinds of evidence would count and for how much, and we would have perfect determinism. And who knows whether that perfect determinism would or wouldn't give every terrorist who wanted to enter the United States a right to have a nuclear weapon. Who knows? Do you really want to commit in advance to that kind of perfectly specified theory that leaves no room for common sense?
Let me kind of flip that around a little bit and look at the Confrontation Clause cases. I mean, that's an area where Justice Scalia, using an originalism approach, has concluded that the Confrontation Clause has a much more expansive meaning than the court had thought decades ago, leading him to be leading the charge in favor of expanding rights for criminal defendants. And you see that in some other areas as well. And ask Professor Case, how about that? There's an example where originalism is leading to results that liberals might like, or is that?
I don't want to represent liberals here.
Well, I don't. I guess my question is we've talked a lot about the difficult cases for originalism, and my question is, you take a case like that, which I think is maybe the best case for the originalists on the Supreme Court, at least, to say, see, here's an area where our theory shows that it's principled because it's leading me to results that you would think I wouldn't like, and maybe Justice Scalia would say, I don't personally like.
I mean, again, I start with the premise that being principled, especially in law, oughtn't to be an end in itself. I mean, law is more like medicine and engineering than it is like physics and biology, right? We need to do what works, regardless of whether it's theoretically pure. And focusing on theoretical purity as an end in itself is even worse than fiat justitiae ruat caelum, because at least then you get justice, and here all you get is a foolish consistency.
Anyone want to follow up on that?